Now we have two bills left. They're both sponsored by Representative Knight. I'd ask that I can introduce both and that he could testify about both because they have one common witness that could testify about both. The first is House Bill 5088, again sponsored by Representative Knight. It's an act related to criminal procedure, bail, and recognizance. It actually repeals sections of the law which would permit the state, meaning the Attorney General's office and/or the court, to draw an inference that a person charged with delivery of a controlled substance is a danger to the community. The second bill, House Bill 5089, again sponsored by Representative Knight. It's an act related to criminal procedure and bail as well. And the act requires bail if not indicted or charged by way of a criminal information. Those are the two ways that one is charged with a felony under Rhode Island law. Within 3 months, they got to allow them out on bail. Representative Knight, the floor is yours.
Thank you, Mr. Chairman. Much appreciated. I'll start with 5088, which repeals the presumption in its entirety, and a little background here for members of the committee who've been here a while. You've heard this spiel from me. Our Constitution allows a person charged with certain offenses to be held without bail for an indeterminate amount of time, just while the case is pending. If the case takes a year, you're held a year until you get your trial. If it takes 3 years, you're held 3 years before you get your trial. So it's a really tough provision, and it's appropriate in some cases. It applies to things like murder and rape and child molestation, but it also applies to certain narcotics offenses, including possession with intent to deliver any controlled substance or delivery of a controlled substance. And that could be marijuana, it could be the heavy stuff, cocaine, heroin, but it could also be marijuana or even Klonopin. So this law, which was passed in 1988 and hasn't been touched since, says to the judge, if you get somebody who is here because of a drug offense and the government is asking you to hold them without bail until their trial, you have to assume that they are a danger of the community. And therefore, unless the defendant shows you some evidence to the contrary, you have to hold them. The law does not do that for child molesters. The law does not do that for murderers. You could kill 16 people on the street, and you would not have to overcome that presumption. But if you're an 18-year-old kid who sells a dime bag to an undercover police officer in the parking lot, guess what? You have to overcome this presumption. I believe that this law was passed right after our last set of constitutional amendments, which added drugs to the hold without bail portion of our Constitution. I think it's representative of the drug scare in the 80s, and I think we know a lot more right now about narcotics and the intersection of narcotics in our communities with criminality, and I think we know a lot more that narcotics are often related to addiction and a medical issue. So I think this law's time has long since passed, and I would vote to repeal it. And if anyone has any questions about that, I'm happy to answer now, or otherwise I'll go on to the next one. Okay, great. 5089 is pretty simple. If you are charged by the police with a felony, the first stop for most people is in the district court, where they're going to charge you with a complaint. You're going to be put on bail, but you have to wait around for the Attorney General to package up all the evidence from the police and formally bring the charge in the Superior Court, which is the only court that can do the guilty, not guilty part of a felony. So currently the law says that if they don't do it in 6 months, then you can go back to the district court and say, hey, dismiss the case, let me off bail. And I think that's too long. I'd like to reduce that to 3 months, and I'll tell you 2 reasons why. Number one, in those really serious cases that I was just talking about, where somebody is held without bail, the deal that is struck between the Attorney General and the defense counsel is usually 3 months. You can hold my guy, but if you don't indict him in 3 months, then he gets out. So this, by changing the law here, I would just conform our existing law to existing practice. Secondly, I would just point you back a couple of years when Attorney General Nerona took over. For those of you who are reading the news, AG Nerona fired everybody who had anything to do with the office that charges felonies, that collects the evidence from the police departments, packages them up, and turns them into an indictment or an information in Superior Court. Fired each and every one of them because of the backlog in that charging office was so intense. There were so many cases that were just old and had not been charged. This law, in its form right now, helped make that problem. So I would just say scratch 6, put in 3, conform it to the regular practice, and let's, if we're going to, let's stay as a General Assembly, if we're going to charge somebody with criminal conduct, let's say that process should move swiftly for the benefit of the victim, right? But also for the benefit of the accused, because justice delayed is justice denied, and that's true for everybody involved in the process. And that is my presentation, Mr. Chairman.
Any questions of the dual sponsor on either bill?
Thank you.
Yes, Jose.
Not so much a question as much as just a quick comment in support of the first bill in particular. Obviously, I support both, having done criminal defense work in my practice. But in the first one in particular, was I definitely agree with Jason. It's a product of the war on drugs. Very sadly, what we see is a disproportionate impact on folks. Right? It's one thing to try to prosecute folks for drugs, but it's another thing to hold them without bail and to put those folks at the very top of the criminal hierarchy, if you will. And I just wanted to give a quick anecdote of a couple of cases that I've had where man is accused of dealing drugs, house gets raided with a warrant, girlfriend / partner is in the house, nothing to do with the operation, gets arrested and charged with the same charges as partner, and she's ultimately held without bail as well. And so you can see how this is a problem that can escalate very quickly, can impact folks very quickly. One small piece, one misunderstanding, or one bad piece of legal advice, and can just trip up folks who have nothing to do with the original arrest. And we were talking earlier about the consequences of a felony and folks not being able to get federal aid to go to school, or if they're in public housing, immediately and draconiously lose public housing. And so these are real things that happen, and I appreciate Jason for his leadership in putting these bills forward, and I enthusiastically support both of them.
Any further questions of the sponsor? The committee? Yes. Representative Felix.
Thank you, Mr. Chairman. I also want to express my support for this bill. It's more of a comment, not a question for Representative Knight. But as someone who had been affected by the criminal justice system with bills exactly like this prior to being fixed and incarcerated for the mandatory period, it's incumbent on us as legislators to fix these issues. These are just not anecdotal stories that we're telling about folks having been charged and spent some time in there, and in some cases for the rest of their lives living with it, but also being able to change it. So I think that it's incumbent upon all of us to really look at this, the impact that it has on our communities, and to do what Rep. Knight is doing and amend them for a positive impact for everyone. So thank you very much.
Thank you very much for your comment. Jason, yes.
Chair, I just wanted to point out one extra thing, and this was top of my list. Of course, I blew right over it. This also referring to 5088, if we were to pass this law, it would do one other thing that this committee has expressed a preference for over the last few years, which is it would add to a judge's discretion in making a decision about bail. And I know this committee wants to make sure that we give judges the discretion so that they can deal with the facts that are presented to them on the ground and basically fulfill the obligation that we hired them to do. Thanks, Mr. Chairman.
Thank you, Representative Knight. I believe there is one witness that wants to testify on both bills. Roberta, it's Randall Rose. He's somewhere in the building.
Chairman, they have Haley McKee on the line for one of these bills.
Oh, okay. All right,
okay?
that's fine.
All right.
You can do Haley first. Haley, Bob Craven again. You're testifying.
Good evening, Chairman Craven. Hi, are you there?
On Representative Knight's bill 5088 that repeals the presumption of dangerousness as it relates to delivery of drugs. Proceed.
Great. Okay, great. Hi, good evening, Chairman Craven and honorable members of the committee. My name is Haley McKee. I am a Providence resident. I am co-chair of the Substance Use Policy Education and Recovery PAC, Direct Action Rights and Equality Behind the Walls member. I sit on Brown's COBRE Advisory Board, which is the Center for Opioids Biomedical Research. I'm also a leader on the formerly incarcerated union. I am on the advisory board for the Warren Alpert Medical School Center for Health and Justice Transformation. I am a former IV drug user, and I'm currently employed as a clinical counselor working with people who are in recovery from substance use disorder or living with substance use disorder during the day. And I'm here in strong support of House Bill 5088. I'm going to revisit Operation Bust Out here for a second because I feel as though it's relevant. For those of you who aren't familiar with Operation Bust Out or can't recall it, that was a deliberate drug sting just about a year ago, where 23 people were charged with narcotics trafficking. And it was overall received nationally and condemned for its style of policing and prosecution. And the reason being is that the undercover police targeted people who were carrying medically assisted recovery medications such as Suboxone, and these people incurred charges for trafficking when they were often charged for dealing one strip of Suboxone or buprenorphine. So 6 of these 9 people were charged for buprenorphine and held without bail over the Christmas holiday. I'm sorry. Did somebody cut in?
Nope.
Okay, sorry. So for these people who were charged for oftentimes $3 or $5 transactions, which was based on basically empathy. So they had an undercover informant that pretended to have withdrawal symptoms. These people had sympathy, sold them 1 dose of their medication, and the result was that they were imprisoned. And 6 of these 9 people, again, were imprisoned over Christmas holidays, and 1 person was actually lost his sober housing, which he had been in for 18 months. So this 4-month-long investigation on behalf of Providence Police netted a sum total of $427 of controlled substances, which, in my opinion, is a complete waste of it's counterproductive of city resources. And behind the scenes, because I work on drug policy pretty much full-time, I spoke with a lot of our government officials, and Police Chief Clements went on the record saying that he acknowledged that it wasn't a high-level drug dealing sting, but it was more of a quality of life issue for people who live and work in the city. And I'm not sure whose quality of life he was referring to, but in my conversations with Mayor Jorge Lorza, he was under the interpretation that these people, it was more high level than it was actually propagated to be. And Mayor Lorza has gone on the record in saying that he will no longer allow these kinds of stings predatory stings to happen. I also additionally spoke with Public Safety Commissioner Pare, who, when they sat and actually propagated this imagery, largely which were for people of color, it was denied. The picture was right in front of their face. They didn't own it. And even the Attorney General, after this was condemned on a national level, chose to prosecute these people, kind of swept it under the rug, made it quick, within 2 months. These people who are basically essentially criminalized for poverty, homelessness, were largely people of color, incurred a sentence of 4 years suspended sentence and a $1,000 fine for people who are overwhelmingly homeless. So this is a practice that they're saying isn't going to happen anymore. But the reason that I touched on Operation Bust Out is because it's not an exception. It's generally the rule. So our organization, the Super PAC, actually did an APA request from the DOC in 2019. This is a snapshot of the current state of things. And this request was only people who have had drug distribution as their most serious offense as of March 31st, 2019. And at that day and time, the snapshot showed that 89 people were awaiting trial at the ACI. Of those people, 54 of them, or 61%, were people of color, and the average length of time awaiting trial was 89 days. So this is on any given day at the Rhode Island Department of Corrections. And the reason that this bill is important is because it's very easy to infer intent even when it's not there. Intent could be anything from a sandwich bag or more than 2 doses of substances on a person on any given time. And we're constantly operating data and getting a pulse on what the Providence Police and other municipalities are doing. And we've seen concerningly a sharp uptick in possession with intent charges, which means that these people are being held during COVID times for what is generally pled down to as a simple possession charge, which is also serious as far as its repercussions are concerned. Currently, there's no difference with drug offenses and charges such as child molestation and murder. And I can say, from an expert opinion, as somebody who works and runs an intensive outpatient program with 10 to 15 people at a table at a time, that these people are not scary. They're not people who are using drugs, selling drugs to use drugs or sustain their own personal usage are not people who are generally threats to society. Does the Rhode Island Scarface exist? Sure. Have I met that person in all of my years either using drugs or working with people who use drugs? No, I haven't. Sure, he's out there somewhere, but I haven't met him yet. Also, a defendant has to currently prove that they're not dangerous. Again, that goes back to most of these people are simple users. These crimes are often escalated unnecessarily. The judges currently have no discretion, so it's the say is a lot. Oftentimes, with the police forces that are targeting people. And we know that the war on drugs has not worked. We know that it's fueled by race and class issues. And there needs to be an extra set of eyes on these cases because we know what that's led to. Again, when we operate data, oftentimes we'll see as much as 88% of the people who are being held on these charges are people of color, even though we know that white people and people of color use drugs at the same rates. So there's some serious injustice there. As far as the higher charges, such as manufacturing or distribution, there was a U.S. Supreme Court case, R.V. that found that the basic fact of possession and presumed fact of possession for trafficking had no rational connection, as it was too vague. So we have a social construct that we've put at 28 grams currently. And oftentimes, even when a person goes beyond possession with intent. I'll use myself as an example. So before I started to use IV drugs, I was taking pills such as hydrocodone that would weigh in typically at 1.25 grams each. And on any given day when I was using drugs, I would take about 35 pills, which weighs in at 43.75 grams. And I certainly wasn't a distributor. I wasn't caught, and there's reason for that. It's because I wasn't profiled and I wasn't targeted. I do think that this bill is important to start to dial back the presumption law, which came from the 80s war on drugs that we know has failed. We know that drug prohibition and the criminalization of people who sell or distribute drugs does not reduce the harms of drug use or improve public safety. And additionally, the Drug Policy Alliance, they stated that people incarcerated for selling or distribution offenses have increased by 3,000% from 15,000 people in 1980 to 450,000 people today. And drugs are actually more readily available and at a significantly lower price. And it's evident by our recent overdose death rate, which is over 400 people for the year of last year, that our attempts at criminalization and the methods that we've been employing are really, not only are they not working, but they're actually backfiring, and it's really at a detriment to communities of color. And I thank you for your bill, Representative Knight, and for your time, committee members. Thank you.
Thank you, Haley. Any questions of Haley McKee? Okay, Roberta, I think we're into our last witness, Randall Rose, on both bills. Randall.
You seem to have been disconnected. We're going to try him one more time.
Okay. Randall? Randall?
Yes.
Okay, Randall, you're up on 5088 and 5089.
Good. So, like other people, I'm in favor of these bills. I think there's been excellent testimony about this so far. Basically, one of the important principles of justice is that you're innocent until proven guilty. You don't get thrown in jail for 6 months or for an indefinite period of time, just because there's a suspicion that you might be charged at some point when you haven't even been charged yet. That's a basic principle of justice. If somebody hasn't even been charged, they should be considered innocent until proven guilty. If they're a danger to the community, fine. Then if there's good reason to think they're a danger to the community, fine. But we shouldn't just assume people are a danger to the community when they're charged with what's very often a nonviolent offense. Possession of drugs is a nonviolent offense, or as the previous witness said, possession of drugs is often misinterpreted by the justice system as being a drug dealer, possession with intent to deliver, but it's a nonviolent offense, and this bill does, this law that is currently on the books does smack of its 1980s origin. It's not a law that should be passed today. Even though Americans believe in the principle of being innocent until proven guilty, there's unfortunately another force in the criminal justice system, which is just neglect. If people are charged and they're more brought into the system, then they're assumed in some quarters to be bad people, and then you just forget about them and say, oh, who cares if they stay in there longer? Unfortunately, the kind of neglect that happens to people who haven't even been convicted or even charged with a crime, it has a lot of really bad repercussions in people's lives. As people who live in these communities know, it has a lot of bad repercussions. And what we have here is a law that sounded good in the 1980s, and due to neglect, it's been kept on the books. The law that's House Bill 5088 tries to repeal the law that says that if you're charged with possession of drugs with intent to deliver, you're assumed to be a danger to the community, and you can be held without bail. We shouldn't be keeping laws on the books that no longer make sense, that seemed appealing at one time, and are would not be passed today, and they're just being kept on the books due to inertia. That a lot of people who could recover from their drug addiction are not being helped by being kept in jail indefinitely, where they may experience more violence and more traumatic experiences. And as many people have said, there is a lot of drugs going around inside the jails. So so for all those reasons, House Bill 5088 is a simple cleanup law and should be passed. And I also support House Bill 5089, which just says that it just makes sure that people are charged within a reasonable time, that they're not stuck in jail for half a year while the government decides whether to charge them, and maybe the government decides, oh, we decided we don't have a case, we'll let you out 5 months later. That should not be right. If there's no good reason to think somebody's a danger to the community and they haven't even gotten around to charging you yet, they shouldn't be able to let you out. They should let you out in jail within 3 months. For those reasons, I support these two bills. Thank you.
Thank you, Randall. That concludes testimony on both House Bill 5088, involving the repeal of the presumption of dangerousness as it relates to the community for being charged with delivery of a controlled substance, as well as setting bail for someone who's been held for more than 3 months. Before we take a motion, I take a motion to adjourn. I want to thank Roberta and her staff of Garrett for organizing this. This was the committee's first, it was our maiden voyage, so to speak, of this Zoom way of communicating with people. We are in a pandemic. Someday we'll tell our grandchildren stories about how we talked into a little screen that looked like the Hollywood squares of my day. It was a television show. But in any event, and the tech staff did a great job. I want to, on behalf of the committee, I want to thank all of you for doing a great job. So, and with that, motion to adjourn. I hear a motion.
So moved.
Jose Batista moves. Jason Knight seconds. All those in favor signify by saying aye.
Aye.
Opposed, nay. The ayes have it. See you Thursday. Thanks.